colleagues, I will move to the item under House Bill 5100, a report from the Judicial Department on their eCourt project. Chief Justice Muniz, if you and your colleagues, whoever you've brought with you, would approach, and then Ms. Lamont, kick us off.
Madam Chair, members of the committee, the department has been requested to report on its eCourt technology project with a focus on the measurable outcomes and the business needs that create the basis for this technology conversion.
Thank you.
Thank you.
Welcome, Your Honor.
Thank you. Good afternoon. Representative Nolan, Senator Schrader, members of the committee, thank you for the opportunity to appear before the committee today. I'm Paul Muniz, Chief Justice of the Oregon Supreme Court and the administrative head of the judicial branch of government. With me today are Multnomah County Circuit Judge Michael Marcus and Multnomah County Trial Court Administrator Douglas Bray. I asked Judge Marcus and Douglas Bray to begin the presentation on behalf of the judicial branch because I believe this committee will derive the most benefit if our presentation is focused through the lens of a judge and a trial court administrator who have been integrally involved in a 5-year planning process, who work in the busiest courthouse in Oregon, and on a daily basis work with the shortcomings inherent in a 25-year-old case registry system. Also here are State Court Administrator Kingsley Click, Sarah Gates, Director of the Financial and Administrative Services Division, Bud Borgia, our CIO, and Steve Davis from MTG. Depending on the questions that are asked during this, they may have some comments to follow up in answer to your questions or some additional points. Finally, I'd like to thank the Legislative Fiscal Office for their dedication and for their hard work on our eCourt initiative. I'll now turn the presentation over to my colleagues.
Thank you.
Co-chairs, members of the committee, I'm Michael Marcus. I'm a circuit judge in Multnomah County. I took the bench in 1990. One of my first assignments was in a high-volume court that did release decisions and arraignments. And I followed what I understood to be the process and the culture, and I made decisions. And a day or two later, I read the newspaper to read that one of the people I had chosen to release had brutalized members of a family that ran a mom-and-pop small business. And of course, I was horrified that I had allowed such a thing to happen. And that began my education into what a case-based system is opposed to a person-based system. A case-based system like OGIN is one that collects information about a case. If somebody's involved in another case, is charged with a new crime, if they misspell their name on purpose, or the officer gets it wrong, or they use a different date of birth or a different identification, or borrow somebody else's ID, they're not connected in any way in our database. The reason that I made a bad decision was in tremendous part that I don't have reliable access to all the information that swells up in our system around us without us knowing it's there, about what other charges are pending, what other history we've had about this individual, what wants and warrants are connected to this person, and I learned from the newspaper article what I should have known before I made the release decision. In 1997, this legislature passed House Bill 2229, which directed all of the criminal justice agencies, including courts, law enforcement, corrections, juvenile and adult, to collect, share, and manage data so as to allow us to link records, track offenders, and learn which of our responses to all of the folks that we dealt with worked best in terms of reducing criminal behavior. Nothing much happened other than the law said what we should be doing. The public safety plan adopted by the Criminal Justice Commission in 2001 came up with its first recommendation, which was Oregon should develop availability of offender-based data in order to track an offender through the criminal justice system and to facilitate data-driven pretrial release, sentencing, and correctional supervision decisions. That was the first recommendation of the Criminal Justice Commission in 2001. The court has created a 2020 vision as part of our regular planning process. One of the pieces of that under partnerships is together we promote public safety and quality of life, improve the lives of children and families, and protect people who cannot protect themselves. We use preventive measures and effective sentencing to reduce criminal behavior. On the right side of the same page, employ technology to improve sentencing practices and data sharing systems. Our case-based OGEN system is as useless in collecting and displaying data that we should see as it was when I took the bench in 1990. All of these advances in what we should be doing, recognition of how we should be focused on our impact on families, children, and the safety of the community, have not improved one iota the progress of OGEN as a resource. Although it contains all the information we need to know all the things that have happened to people in our family courts, in our juvenile courts, and in our criminal courts, we don't have access to that information because it's a case-based system and we don't have the modern technology to collect and display the information. What's urgent about this is we're still making release decisions without full access to information. Full access to information about what risks, cases, prosecutions, and behaviors we already should know are associated with this person. So we're going to release people who will do harm that we wouldn't release if we had that information. Equally, we don't have collected visions of the data that surrounds us that we've already collected to see which dispositions for which offenders under which circumstances brought them back without a failure to appear and without a new crime. Those are two kinds of ways of using data, and it's our vision and it's part of our plan in collecting and sharing data, making it person-based, to give judges and all of those who interact with the system this kind of information. The same thing is true of release decisions as is true of sentencing decisions, probation violation decisions, delinquency and dependency cases. We don't know whether somebody has a case for a sex abuse conviction when we're dealing with the same person in a family law situation or a dependency or delinquency violation to determine whether they should be placed with that person who, by the way, with a different date of birth in our same OJU system, may have some very concerning convictions and backgrounds that we should know about, but we don't get to look at. The same is true with custody disputes, where we're making decisions about which parent should get the child. Wouldn't it be nice to know if that parent under a different name or a different date of birth, or we just didn't have the connection and the software to show it to us, was convicted of a series of domestic violence cases, or assault cases, or theft cases? There are all sorts of pieces of information that lurk in our database that we're not using now. Every day that we proceed without this kind of access to information, we'll be making decisions that harm Oregon citizens, families, and children. They can ruin not just a business, not just a couple of days or a week. They can ruin lifetimes if we make decisions that more information would have prevented or changed with the placement of children. We cannot share data with law enforcement and corrections so that when we issue a family abuse protective order, it may take a long time and be unreliable before that gets into the hands and on the computers of the law enforcement people we depend upon to enforce it in time to prevent the assault or the homicide. The urgency to all this is that we are allowing harm to happen because we have an archaic system that prevents us from accessing information we all should have when we make those decisions, and it prevents us from seeing what's worked under which circumstances, under offenders, family placements, custody decisions, visitation decisions. That's the urgency to this. It's been going on for years, and every time we delay it, there are more people hurt by the mistakes that I've listed.